welcome back to Law Unfiltered. Today we're going to talk about buying properties. Now, buying properties is definitely one of the quite a big financial commitment that we do for our lives, other than getting a child, which is definitely more
Yeah,
expensive.
which is a worth commitment, very much worth it.
Something that I will understand in the future.
Yeah.
And of course, today we are not going to do it alone. We are going to break down how buying residential properties and commercial properties may differ from one another, together with Miss Sharon
Hello.
from Mrs. Gan and Zoe, being one of a partner here in the firm. Thank you for being here, Miss Sharon.
Thank you. It's an opportunity for me because I have been doing conveyancing for the past 25 years,
Yeah.
and this is part and parcel of what I do.
Yes,
And
I
so
believe you must
let's
have
educate.
a lot of insights that we can
Yes.
have for everybody.
Yes.
Right. So now, a lot of things, many of us actually have a misconception between buying residential property and commercial property. In fact, I believe most of us don't actually know what is the difference between buying these two properties, because in our mind it's just like, okay, buying a property, okay, let's go, right?
Yeah, that's
So
true.
now we are going to tell you what is the difference being buying like residential property. Now, residential properties are protected under the Housing Development Act,
That's
which
right.
is a social legislation enacted for the purpose of protecting the rights and interests of purchasers. Because you see, developers are obviously they have more power when it comes to bargaining a contract and so forth. So purchasers may not have so much say sometimes. So that's why Housing Development Act has been enacted at the material time. I can't remember. I think it's 2014.
It was enacted. It started in 1969. That's the first act. In 1969, thereafter, it changed 8 to 9 times over a period of time. 2015 was when it changed. The last change.
To more like
They included
updated lah.
yes, updated and they included a lot of clauses to protect the buyers.
Yeah, and like I believe like in terms of like SPA sales and purchase agreements, when it comes to residential properties, there are certain guidelines or terms in the contract that the developer definitely have to strictly provide in the SPA itself.
Don't we talk about the difference between residential and commercial? Because what happened in 2015, why was there a change of the act, was because everyone was getting confused with service apartments. Is service apartment under commercial or residential? So what they did was they defined housing accommodation in the act as human habitation or partly human habitation. So prior to the act coming into force, what happened was, do you know developers get very creative with having SOHO, SOVO, SOLO,
Yeah.
so shop office, home office, shop office, versatile office, office, luxury office. Okay, they came up with these names, and these are all actually service apartments. Service apartment is supposed to be under commercial property.
Yes.
Right. So what happened was the act was amended to include all these into the HDA. So what they did was they defined the word housing accommodation to include human habitation and partly human habitation. Why? Having a floor plan and you have the office table there, you have another table, then suddenly you see a bed, partly human habitation. That's what the act now provides. Sorry, developers, all of your properties now is governed by HDA. So residential properties now for apartments, service apartments, it's also residential, no longer commercial. So that's residential. So it's governed by the Housing Development Act.
Correct.
So it can be either Schedule H or Schedule G.
Correct.
I and J lah.
Yeah,
All right. So
correct.
we have got the 4 schedule. Then we have commercial properties. Now, what are commercial properties? It can be service apartments as well, which doesn't come under the HDA, but it's actually offices. It's office suites. Okay.
Do you have like an example of the project that you have in mind right now?
I have Center Stage in PJ.
Oh yeah, center stage. Yeah.
Yeah. So that is under commercial.
Okay, the downstairs is the shop lots,
So
and then
the
the
units
upstairs.
upstairs are all commercial units, but actually there are human habiting there. So we have residents staying there, but it's actually a commercial property, right? And the agreement we used there was not under HDA, was a commercial SPA for all buyers.
Oh, this is new to me.
Yeah.
Sorry, I didn't do conveyancing,
Yeah,
and I'm too
yeah.
broke to buy a house right now. But okay, so okay, let me get it straight. So center stage, like let's take that for an example. It's mixed, right?
It's mixed development.
Yeah, but what made it under commercial?
Okay,
Commercial
so that
part.
was prior to the amendment 2015.
Oh, I see.
Okay, so they put a bed. No, they put it's an office. There's no bed there. It's an office suite, but they have a clause in the booking form
Okay.
to say that you can actually stay, but nothing stipulated in the agreement.
I see. But now, after the amendments have been made to the HDA,
Property completed. They are staying there, but many have sold the properties now. So we heard that. I mean, they can't even get a buyer to come in to buy the property because of some issues with the maintenance. The mixed development, there were some issues which I think I want to be quiet about it. So,
yeah, okay.
so yeah.
No problem. Oh, so let's just say right now today a new project comes up and it's mixed again, commercial. Downstairs will be shop lots, and then upstairs will be like for residential. And then in the floor plan, the plan itself, if there is no bed, then it will be completely commercial. Is that what you're saying?
Yes and no, because now when you apply for building plan approval, you have to already state there whether it comes under HDA or not.
Oh,
So prior to you having your plans in, your building plan approval is the first step for your project.
yeah.
So that's where you state actually you want it's a residential property or a commercial building.
Yeah,
Okay.
yeah.
So it can be a residential property but on a commercial land, that you're aware, right?
Yeah.
So tanah perniagaan.
Then they have to convert
then
it
you have to
later on,
convert
yeah.
later. So it all depends on how your building plan is approved.
I see.
So that's your first step, the developer's first step. So now, what happened now is the Housing Ministry, they are very strict. They will really go through your building plan
Yeah.
and they will ascertain whether whatever you have submitted, your plans, your units, it comes under HDA or not.
So that they cannot do any hanky-panky
Yes,
behind there.
Yes.
Oh, I understand that now. Okay, that's
Yeah,
really good to
yeah,
know.
yeah.
Okay, but now that we understand that the differences between how different service apartments can potentially be commercial or non-commercial, I believe when we are buying the property at the end of the day, we will know. It will be stated there anyway.
It will be, but you see, we got to educate our fellow investors or buyers, first-time home buyers. They are just there. They are excited to buy a property, right?
Yeah.
Like how you will react when you get your first property.
I will
Like,
come and look for you. Like Sharon.
like oh, I've got a property.
Yeah.
But do you know what you will be signing with me? No,
No.
you wouldn't know. You
Yeah.
wouldn't know. You would actually leave it to your lawyers.
Yes.
Or you will trust the developer,
Yeah.
right? So it's so we got to educate them to tell them that not everything is standard. You got to still check. So, but when you're talking about residential property, which comes under the Housing Development Act, so that's standard, right?
Yeah, that's standard.
So, but we still guide the purchasers on their rights in the sale and purchase agreement.
Yeah, of
Right.
course.
So,
Right.
so what are the important clauses in the residential?
Definitely the vacant possession part.
Right.
Right.
So firstly would be what happens if, okay, so vacant possession is delivery of vacant possession.
Correct.
So it's either 36 or 48.
Or
Or
24,
Oh, 20
24, 36.
24 if it's landed.
Landed,
So
Schedule
if it's
G.
36,
Yeah.
or if it's 70, I don't know. Maybe now they have
Yeah.
got a right to get an extension of time, right?
Yes, and I think a lot of people, they didn't, like I say again, sometimes they just leave it all to the lawyers. Like But it is possible, I've seen a few cases, it is possible that at the time when the purchaser is signing the SPA itself, it would have been extended already after they get the approval from the minister.
Right.
So that's why I think sometimes there is this confusion that comes around, oh, why is it more than the stipulated time provided in the HDA itself? It's because they already have the extension of time. And usually if the minister allows it, it usually will have like a very reasonable explanation.
Yes, you got to state reasons.
Yeah,
Okay, I'll give another example. We did a project, a very well-known project in KL, in the heart of KL city. All right, so they asked for a long period of time, even beyond the act. Okay, so why? The reasons given was because it's in the heart of the city. You want to develop a project for the lorries to come in. For them to send the materials and all that, there's traffic. It's difficult to get approval and timing. So the ministry looked into all this and granted the approval. So how does the ministry give an approval is it depends on the situation. And your reason has to be legit,
substantial,
substantial and legit. You don't simply give a reason, right? So they were able to prove that under DBKL, it's in KL, there were timings where the lorries could come in only a certain period of time. Right? So all that was taken into account for the developer to get an extension of time. Now that was very interesting because the buyers for this project were all, it's above 1.5 million, right? So the buyers were all
angry
foreigners and they were very
baffled.
Yeah, so they didn't understand all that. They wanted to know why did we amend, or how come did we deviated from the act. But we had letter. So because this is a very well-known developer, they came prepared. So when we signed the SNP with the buyers, we actually showed them the letter. Yes, so there was already a letter.
But they still came back and asked why.
They asked why, and then we gave them the letter. But it was still not completed on time, despite having that letter.
EOT.
Yes. So that was another issue they had to deal with for other reasons.
But I mean, after they have granted the extension of time, and if they fail to provide vacant possession at the stipulated time,
they can actually write in and request for a further extension. But there was a timeline for them to do so,
and
they crossed the timeline. So that was an issue there. So I think I'm not sure what is the timeline, but prior to your expiry of your EOT, right? You have to write into the
which is,
but they did not do that.
Too bad.
So but I know many developers as of now, when they get the buyers to sign SNP, they already have that letter. So I'm not sure whether the letter now is readily available. For most
there's no harm, right? Because when we buy property, we want to be well informed of the situation. So if you show me the letter, I do not see that it will be any prejudice caused to the developer in any way.
It does not. For developers, if you extend, pros and cons is the more you extend, you see your profit later, right? But for the buyers, when you extend, they want the property. Either maybe it's their first home, they want to stay, or they want to invest. So you are delaying them.
And you are denying them the time to get the liquidated damages as well. So you see, this is another right that purchasers have under the HDA itself, which is liquidated ascertained damages, is when developers provide vacant possession later than the stipulated time, then you can get liquidated ascertained damages according to the SPA itself. But if they get EOT, then of course the LED will be delayed too, and that's why sometimes purchasers are unhappy about that situation, because like you say, if they want to invest and the investment is being delayed, they do not see the return of investment, and then on top of that, they are being denied from obtaining that damages as well. So that's where issues arises, and sometimes people file for judicial review as well to counter with because they disagree with the ministers.
All this is cost, right? And time. Again, it's time-consuming cost, but that's their only revenue.
That's true. There's no other way, but it's good for us. It's more money, more file, more,
Good for us.
Good for us. Anyways, This is really interesting because I don't think a lot of people understands how these things can play a part when it comes to buying properties. Like you say, we are very excited to buy our first home.
Yeah, but what are you signing?
Yeah, what are
That's
you
another
signing?
thing, yeah.
You don't know. And I think it also that comes with the risk. Like for example, what if developer didn't do anything for the first 6 months when they have purchased the property after executing the SPA itself? What if I want to terminate the agreement, but under the law itself, the only way you can terminate the agreement if the developer fails to do anything for the first 6 months
Yeah,
is only if 75%
75%.
of the purchasers
Yeah.
are willing to terminate and
they come together. And,
and the minister approves that termination itself, then only you will get a full refund of the purchase price that you have paid for.
Correct.
So that's quite a big hurdle to go through as well.
So that's that part where I think this is something where many buyers, they prefer to go back to the previous act. Why? Because if the developer doesn't act on the transaction, on the SPA, and I think there's a schedule where if you have completed the property more than 50% or less than 50%,
then you cannot.
Yeah, so there was a guideline there in the SPA, in the clause, but now you got to get 75%.
That's a lot of people.
So some may not even want to proceed, or they can wait.
And I think this also, I feel like this is also one of the reasons that maybe that's why some projects are being abandoned. Right? And they have absconded or something. I'm not sure, but
that is covered under the act as well.
That's true.
Abandoned project.
That's right. So now that we know that how purchasers are being protected under the HDA when it comes to late delivery of vacant possession, how we can claim for damages. How we can challenge the minister's approval for extension of time. Now we go to commercial property.
Interesting.
Now commercial property is like any other agreement. You sign, you agree. You cannot say that, I didn't really understand, I didn't really read it. But you've signed, so under the law, it is stated that if you have signed something, it is deemed that you understood, you consented, and there's no dispute about it. Now, a lot of problems arises when people don't read or understand. Because you see, our rights are not really protected here. The defect period may be quite bad, for example.
So for commercial, right, normally who has the right to draft the agreement based on your...
Developer.
Definitely, right? The developer would say, like, I'm the buyer.
So I would draft.
No, assuming you are the buyer, since you have not got a property. Assuming it's your first property now, you signed a booking form with the developer, and now the developer says, okay, you have 21 days to sign the SPA, right? Now, are you given the opportunity to appoint your own lawyer?
I mean, but this is different here because as a lawyer myself, you know, I would have taken note that okay, I have 21 days to get to sign the SPA. Okay, but of course, subject to any extension of time needed because I need to read the agreement myself.
Correct.
Right.
So you will not have a lawyer. Most likely, they will say, no need lawyer. One lawyer will do standard.
Yes.
Okay, it's standard. You don't have to worry, right? So they will have their lawyers giving you the SPA.
Correct.
And of course, an exception for you, you're a lawyer, you would definitely go through word per word. And you would come back and ask your conveyancing lawyers or whoever,
definitely,
right?
correct.
And ask. So what's the catch clauses which I have personally reviewed where the developer, it's always one-sided, I would say that because I've seen like 9 out of 10, it's one-sided. Right? So you have time to sign the SPA, you don't sign, your booking fee gets forfeited.
Correct.
Right? You don't have law to protect that.
Okay.
So you have, and then you dispute on your timeline for delivery of vacant possession, that's not covered as well. But most likely it's 24 months.
Is it?
I've seen agreement, it has gone up to 24 or 36. If you're buying factory, if you're buying some other commercial project like an office block or what, then it may be 24 to 36 months, right? Now what happens if they delay? do you think you will see a clause to say that if we delay, we do not deliver vacant possession on this time, we'll pay you 8% or 10% per annum?
No, I was just reviewing a commercial property agreement, and I realized that not only the the vacant possession is a problem.
Yeah.
Even the covenant is a problem. Why is there only covenants for
the
purchasers
purchaser and
to
not
pay
the-
on
yeah.
time? What about covenant for the developer
Yeah.
to provide vacant possession in due time?
Yeah.
And then how about my damages if you late, or if you are seeking for an extension of time? And on all these things, like, do I get informed? Do you let me know? And then every term in the SPA specifically deals with the timeliness on the purchaser to pay.
Yeah, there's no timeline for developer.
No,
right? Yeah.
no. And the worst thing was that in the SPA itself, the delivery of vacant possession is not the building itself. It was
just
the infrastructure.
structure.
I'm like, where is the vacant possession of the building?
Yeah.
Like, if my client were to not have his own set of lawyers to actually review this SPA, he would have signed it.
Yeah.
And then when he wants to have he wants to come and challenge the SPA, it will be too late of the day because
Yes, he has signed on it.
Yeah, he has
It's
signed on it already.
Yeah. And normally
yeah.
they will get the infrastructure ready
Yeah.
so that then they can start the claim. And another important part is this: your schedule of payment of purchase price. When you sign an SPA under HDA, it's upon completion of each stage,
Yes,
right?
correct.
And with architect cert.
Yeah.
But if you sign a commercial, it's always
Commencement.
So the moment I commence, I put one brick, I'm already billing you. You
Yeah,
pay.
correct.
So, okay, I put one brick, but at the same time, I'm getting ready my infrastructure. My infrastructure gets ready, but my building is not ready.
Yeah.
But it's delivery of VP. So these are the things that the purchasers are not aware. They wouldn't know how to dispute this.
Yeah, and it's too late of the day because
late,
you
yeah.
have already signed
Yeah.
the contract itself. What is there to dispute about at that point of time,
And
right?
What about defect liability period?
Yeah, like for defect liability period, if you are under the HDA, you are also covered
Yes.
because it's standard 24 months.
Yeah.
And within the 24 months, if you file a complaint, the developer have to deal with it within 30 days.
yeah.
If they don't, we can deal with it ourselves and then we can claim
can
back
claim, yeah.
from the developer, or you can just file a suit and
Yeah.
claim back or anything. But sometimes these things are not protected under the commercial SPA
Yeah.
itself.
Most times it's not.
Yeah.
So HDA, you have a stakeholder lawyer coming on board, right?
Yeah.
To hold your money
Correct.
as stakeholder for 24 months.
Yeah.
Okay. So at least the money goes to the law firm as stakeholder. Even if the developer doesn't do anything, I am well assured as buyer that after 30 days, I get my own contractor, I repair, and I give the invoice to the
Yeah.
the lawyer maybe. It will be paid. But in terms of a commercial unit, the SPA is silent.
Yeah.
Yeah. So I have advised many purchasers as their lawyers. But sadly, the developer has their own lawyer where they say that it's a standard SPA, take it or leave it. So I asked the purchaser to make a commercial decision because if they are investors, right, I said then you got to decide commercially whether you want to proceed. But these are all the setbacks in the agreement. This can happen.
Yeah.
So you got to decide. So for them, it's cheap. The property is worth. They see money in future, so they went ahead with it. So it's a risk the buyers take. So I always ask my client, you got to make a commercial decision now because if you really want the property, then all this I can't dispute on the clauses because you want the property. But if you feel that I want the property, but I want to be protected as well. So I'm willing to let go the property if I'm not protected. Then we will go through the SPA. But many developers do not entertain our amendments in the SPA. So when the buyers appoint their lawyer, right? So we amend. We have always a lot of amendments, like what you did, right? For your
I
matter.
amended a lot of things. Yeah.
But they didn't agree. So then we got to leave it for the client to decide whether, do you really want me to go through this road? Because we know where we will end up.
Yeah,
You know.
definitely.
Yeah.
When I look at the agreement, I'm like, there's going to be a lot of dispute. What if something goes wrong? It's definitely you cannot go to court because you have already agreed on the SPA. There's no recourse anymore at this point of time.
And you would have paid your 10%
I don't dare to
as
sign.
well. So.
I don't know how to ask my client to sign the SPA itself. So I think you're right. Like in terms of like making a commercially sense decision whether you want to sign
because
or
we
not.
as lawyers we can only advise them on the clauses and the legality and what happens if this backfires, but at the end of the day it's their call. So we as lawyers, we got to protect ourselves as well, so we got to put everything in writing, and they decide that okay, they want to proceed, but we had already warned them of all these clauses. So that's how we protect ourselves as lawyers.
That's true, yes. But I'm just thinking along the line, like in this case, it seems like we go back to the principle of why the HDA was enacted in the first place, which is to protect the rights of the purchasers and also so that parties can decide at arm's length, right? Because one party has more power than the other.
Right.
And it seems like in commercial building senses, it is the same, don't you think so? Like purchasers are not truly protected under the commercial property wise, and if we go to court and we argue that I don't know, it seems that we're being
if you go to court and argue, you got to prove your loss, right? So what actually are you going to court? Unless
what is the cause of action?
Cause of action, correct. So they can go to court, but what are they claiming? Have they suffered loss? What happened? So you got to really prove your loss, right? So what I'm saying is you already spent so much money buying this commercial property, and it fails, and you go to court. How long will that take? More money and the time. How long will that take?
3-5 years.
Yes.
Tops.
Yeah.
Damn. Yeah, that's quite true as well.
So I don't know if there will be an end to this. I really don't. But I have seen, we have all seen the HDA. Let's talk about the commercial property now, the developers who is now selling commercial property. If they were to use a SPA, just like the HDA. Okay, so they use a HDA format. They've got their timeline for completion.
Correct.
Which is good. They may not have extension of time because they are not governed by the ministry, right? So they have timeline there, but whether they would include a late delivery interest there, that's another thing.
Yeah.
But then it benefits them to a certain extent because they complete the property fast, they get their money, right?
Yeah.
So they avoid all this penalty, these purchasers suing them and all that, right? Then they have this defect liability period. So defect liability period is always 24 months, but I've seen for commercial it's 12 months. It's 12 months. Some no, some you got to ask, some is even 6 months. I've seen all that. But is there a process to go through? That's silent. But even if the developer have this process to say that within 30 days you claim, you check and you submit your claim.
And you still have to prove that it is really because of the workmanship that has caused this sort of defect, right? What is the process of proving that it's really because of what happened when you were building?
Correct.
That is also silent. Yeah.
But so what I'm saying is, if only these developers, they can still use the Housing Developers Act agreement, but with a bit of modification. Because the HDA Act is statutory based, right? It's all governed and there's timeline. So, I've seen 1 or 2 developers who have followed the HDA Act, but just a bit of modification.
I see.
And it's upon completion, the stage of completion.
I think they still have to comply with that, because at the end of the day, if you don't, then that would be a breach of the contract itself, unless you got the extension
of time.
Yeah, but
So we would still come back here in a few years' time, and we will still talk about this, because I've been doing, as I said, 20 over years, and I'm still seeing it today.
Yeah.
The first project I did was a commercial project, but that's how I learned commercial agreement. It was so unfair. So unfair, but we were acting for the developer. So we had to but we acted for the developer at all time, not the purchaser. So whatever the purchaser is entering into it's their decision. So we just
And most of them didn't have a lawyer, right?
no. But I guess those days was different compared to now. The buyers are more educated. They know what to ask. They know what to look out for. But those days, like maybe 10 years ago, they just sign because they believe the developer. Like, developer, you are everything. You know, I'm buying a property from you. You're going to give me my property. And then it starts. But I think 10 years ago, it was okay, I would say. I don't know.
I wouldn't know.
I think 10 years ago, I never had so much of issues, dispute,
When it comes to
or
developers, being hanky-panky.
hanky-panky.
I see.
I wouldn't say they are hanky-panky. I just think that they are thinking out of the box now.
Yeah.
They are becoming very creative.
Yeah, so that they can earn the most profit
Yes.
at the advantage of the purchasers. I see. Okay. Now we know who to go to if we want to buy a property.
Yes.
So I think here we definitely have seen how our rights are being impacted when it comes to buying residential properties and commercial properties. What are the things that essentially we have to look out for? Always read, ask a lawyer if you need.
Yeah.
Just pay like 1,000, 2,000. Give a lawyer to check your SBA.
Yes.
It will save a lot of hassle. You have no idea how some terms can come back and haunt you when something goes bad. Right? Just spend that small amount. Let us read, at least we review. We know what to look out for. Maybe certain things we can tweak a bit, right? So I think that's all for today. You know, I'm so glad to have you here, Miss
thank
Sherry.
you,
Thank you
thank
so
you.
much for being here. I think I learned so much when it
Yeah.
comes to like buying properties and all that.
So looking forward for your property soon.
Yeah, hopefully. Fingers crossed. Okay, thank you.
Alright, thank you.
Alright, see you on the next one. Bye bye.